Trade Turbulence, Strategies for Brokers to Navigate Change and Mitigate Risk. You'll be hearing from LENNY FELDMAN and Karen RZESZUTKO, and SHEILA Skipper is our moderator. A quick reminder to our virtual audience, please use the Q&A feature in Teams to submit questions throughout. SHEILA, over to you.
Thank you. You kind of took my line of what today's discussion is going to focus on, and that's strategies for brokers to navigate change and mitigate risk. But we're going to do a very open-ended question to LENNY. What are the greatest challenges for brokers with the current trade policy and tariff changes?
Absolutely. Well, thanks. And before I answer that very heavy-duty question, I just want to thank Roanoke for being a partner with Sandler & Travis and Rosenberg for decades at this point. It's a real privilege to be here and to speak with all of you in person, and for all of you who are with us virtually. I want to start and answer this question now in two ways. First, as far as the challenges go, I understand, I think we all understand, this is such an unprecedented time as has been stated, but you're going through a lot of changes in your company. And I know this because the companies you are working with, your customers, are the same customers that oftentimes I deal with in my firm. And the challenge at a highest level initially is not just to be a customs broker, it's not just to be an attorney, it's not just to be a surety or bond agent, it's to be a business advisor, a business counselor. And all of us in similar ways are going through that. Do we have a team who is going from burnout to build up? And that is the core challenge right now, to keep the morale up, to make sure that the appropriate tools are available, to make sure you have enough staff. My firm, just this year alone, we had to increase our team by about 20%. And the year's not over and it's still growing. And it's necessary to do that in order to keep up. We have to make sure that we are embracing automation, we're embracing AI, and we're studying that. We subscribe to certain AI tools. I will get from clients initially checking out, is this a fit? Hey, here's the answer I got from ChatGPT. I have to know at this point where ChatGPT actually is going to be somewhat effective in answering the more basic fundamental customs and trade questions, and where it will not. It will not, I can tell you, when it comes to dealing with Section 232 aluminum and steel, and at this point copper. Didn't even know that copper was a thing until a few days ago because we didn't. And I had customers insist that ChatGPT would enable them a few months back to take a Chapter 73 or 76 metal, and they were able to, if you will, segregate the metal from the non-metal component, which wasn't the case at that point. That's what ChatGPT told them, but I had to tell them it wasn't a case. Thankfully, I happen to be right. I had somebody this week say, ChatGPT, that their fertilizer component coming from India should qualify under the Chapter 98 exemption for agricultural implements and machinery. I could tell them that is not consistent with the rulings, as some of you might know. So you have to embrace it. You have to understand and at least assure your team it is not going to replace them, but you have to consider those tools. That being said, the challenges go from there, not only keeping up with the morale, but making sure that you give accurate information. I would rather give on any day of the week no information, no answer, than a right answer. In my whirlwind of where I am, not only serving as counsel to national customs brokers and forwarders and speaking with brokers on a daily, if not hourly, if not on a second-by-second basis, and working with not only counsel in my practice, but counsels around the country, because we've had to band together to figure this all out. There are areas that will be very clear, and it'll be very evident right away. There are areas that are very gray. And it is identifying and knowing what are the clear areas that at your level of competence, you should be able to answer in a way that you're confident about and you're clear about. And those which you have to simply tell your client, I'm not in a position right now to give you that answer. I could tell you what may or may not be reasonable in that situation, but we don't have that guidance. We are all turning to frequently asked questions as our guide, as our holy grail on cbp.gov. And customs will very clearly say, we're sorry, that's not binding legal advice. And then it's hard to track it, although we've requested CBP to do that. When did an FAQ change? Do we have a track changes for that? Not really. So what might have been the right answer a month ago, or a week ago, or a day ago, or an hour ago, that's no longer the right answer, according to the FAQs, but it might change if you get a binding ruling. Coupled with some of us on a regular basis communicate with the centers of excellence and expertise, particularly the base metals, and they're really in the thick of it. They will offer advice and they will really try to get you advice on some of these issues, but it will not even be consistent with the FAQs that are being issued. There's not a uniformity. And this isn't a dig at customs. Customs, I have such respect, I always have, for the role they're in more than ever, because they are getting the executive orders, they are getting the language at about the same time that we are. So you have to understand, your clients have to understand, your staff and team has to understand, it is so fluid, and you have to make sure, that's the challenge, to make sure that you're really at that line where you are exercising reasonable care and you are working with your importers to make sure they understand their obligation to exercise reasonable care to complement your responsible supervision and control as a customs broker. So I know that's kind of a lot to throw out, so I'll stop there.
I think, no, it's very good. When you talked about the gray areas, Lenny, what are the resources that you see with customs brokers to find out some more solidification and get out of maybe the gray area? You know, would you expect that they would talk to you, talk to consultants?
Yeah, I think it's a combination. I find that some of the best expertise in the country is the customs broker. Now, in your brokerage, who has that expertise? Do you have your steel and metal experts? Do you have your agricultural experts, for example? Do you have your valuation experts in-house? And then you need to find them, whether it's a consultant, attorney, working with your sureties as well when it comes to different types of enforcement claims. You really need, there's no better substitute for people, number one. Number two, are you getting the training? Are you going to those seminars? Are you signing up for those webinars so you're getting that cutting edge information? And I would suggest that you do a variety of them and don't keep it a secret. If you need to bring the team together on a regular basis, that's another best practice that we do on a regular basis. We have our IEEPA team. We have our first sale team. We have a forced labor team, and they intersect and they report in to the entire company, not only to the executive team, but to each other to share information. They say sharing is caring. Sharing is more than that. It is indispensable for you to operate, again, consistent with responsible supervision and control. For now, SHEILA, we're going to have the frequently asked questions. We're seeing some rulings come out. There's some good rulings that came out on what constitutes an informational material, which is the holy grail, exempt from all the IEEPA tariffs. Some rulings came out on that, which was interesting. You have to keep up on those as well. So I think there are some tools there.
Great.
But it is just a drinking from the fire hose type moment.
Sure.
That you really have. I think it's good. Generalists are important, but have your specifically focused people. I read every executive order, even in my role managing my company. I know it would be irresponsible for me at least not to sit down and read every executive order as it comes out, read every CSMS, read our communiques that come out. So at least at that level, I have that understanding and knowledge as to what's hitting. And that's the key, as was mentioned, any executive in any company, they need to think like that. The executives we're talking to, they're getting very savvy with this stuff. So you have to be savvy as well.
I love the idea of a subject matter expert. Clearly, our panel here and all our panelists today are somewhat to that degree, right? And I think that that's really important. And one thing that's always so valuable is the communication. And so I think you're absolutely right. Sharing is caring. I love it. It's going to be our new motto for the day.
There you go.
Karen, I'll ask you somewhat the same question, because in our role as an insurance broker, we're certainly seeing challenges for brokers due to the current trade policy and the tariff changes. What is your take on what we can do to consult and be advisors to our clients in that regard?
Yeah, I mean, there are a lot of things we could do. So if we are seeing bond insufficiencies, of course, so that's the top thing for our customers right now. And our clients, you know, they're coming to us to say our bond is insufficient. What can we do? How can we calculate it? What things can we be on the look for? Our first panel talked a little bit about some of those things. And for bond insufficiency, it's difficult. You really need to know your trade lanes, the commodities, you know, who the shipper is. Those things are really important in being able to determine what the bond amount should be going forward. So if you know the trade lane, you know where the goods are coming coming from, you have a pretty good estimation of what that duty rate or tariff should be on import, particularly when it relates to commodity specific and country specific. So those are one of the big things that we see, obviously constantly changing tariffs and the impact that that brings to a custom broker. It's such a fluid situation that, as you mentioned, Lenny, you really have to stay on top of politics today, what's going on in the world, what changes have there been made to tariffs, because it is so constantly changing. It's an ever evolving world, and I don't see that changing anytime in the near future. You mentioned AI. We talked about AI in the panel as well. AI is a large learning model. So it's a large language learning model. Learning is the key word, I would say, is that it's always developing, and you should vet the information. So never take what you're getting back from AI as it is exactly as it's supposed to be. So I always tell people that, you get information back. I use it as a tool. It's a fantastic tool to apply to your everyday, but you use it with vetting in mind. So you get the information back, and you kind of have to validate what's come back to make sure that it's actually accurate information. I always say Google's your friend. AI can be your friend too,
Right.
if you use it in the right way. You get a lot of great information on Google and AI. Now Google, when you say Google's your friend, AI comes up. So it's an AI response in the first instance. And then, you don't stop, I would say too, at the first AI response. Go down into the Google searches to see what else might be there.
So I'm really glad Karen raised that, because AI with guardrails, right?
Yeah.
It's AI with guardrails. As
Absolutely.
you're going through that. We've had some very important discussions in our firm about embracing AI and what happens if any of us, whether it's a seasoned professional, 30 years, an associate, says, I guess we're embracing AI. I'm going to use that, and I'm going to provide that work product pretty much to my client. And we're fearful of that. It is a starting point. But on the other hand, is that going to then move the pendulum in the other direction, where that becomes the company's advice?
Yeah.
That becomes the advice you're providing to your client.
Oh,
So
we've
you have
been
to be very wary of it as a starting point, but that's it. It should not be a substitute. It should be a complement for the
Agreed.
research, for going into cross and looking at the rulings and looking at what's on cbp.gov. In addition, there are real legal considerations when you're using AI. I'm getting discussions from the top tier brokers saying, hey, we are being asked by our AI partner if we could take our client's data and provide it to this third-party service provider. And it's not going to indicate who the importer is. It's not going to indicate the entry, but it is going to utilize that data in certain respects. And my comment is, does your importer customer know this? Have they approved it? There's something called in Part 111, confidentiality of brokerage information, the information you're receiving as a broker. So maybe, and we've done this, we need to look at your power of attorney. We need to look at your terms and conditions. And we've even now started creating a little bit of a newfangled language that says, this is to advise you that you approve as our customer, as our importer, that we may be using your information, not specific to your entry, but for that type of automated third-party purpose. Now, to an extent that was happening already, but it's happening in ways we've never seen before. And I would not want a good customs broker business to run afoul of their obligations and understanding with their importer if they were to find out through the back end, oh, your data looks great. Thanks for sending it over to us. We never knew you were going to get it through the broker. So there are real considerations as to even how you manage that whole process and manage it appropriately, let alone use it to begin with.
Well, and on that, the consultant exposure, I think it's big from an E&O perspective.
Right.
So you really need to make sure that you have the proper E&O coverage for this, because if customers are coming to you more often than not and asking you for advice, you don't want to rely on these things. You need to really properly vet. And I think updating your terms and conditions to reflect how they're using their services as a consultant is a great idea. Great
What
tip.
if there's a data breach somehow now that you're sharing that information? Yeah.
So true, so true.
Yeah.
I hate to go back, but I kind of want to touch on IEEPA, which you mentioned earlier when we first got started. What the concerns are and the significance and importance.
Of IEEPA? Just a few. So look, I think we know what some of the concerns are. How do we, there are opportunities too. Let's be honest, okay? This, to an extent, folks, is our Super Bowl. Okay? Anyone in this room who has been doing this for decades or doing, I have folks knocking on the doors. Hey, I've never had a career in international trade. I want to do this. How do I get in? This is what I want. And I think a lot of you might be hearing that as well, that the interest in this space is just incredible. I think some people are repelling and some people are propelling right into it. Okay, it really is going to come down to how are you going to reimagine not only your business, but advise your customers how to reimagine their supply chains. That's what we had to do several years back when it came to the pandemic. We had to rearrange and we had to realign how we thought of communicating throughout the world. We had to look at how we were now getting commerce through. Well, folks, we're currently in what I call the trade-demic. The trade-demic, okay? And what and I've been using that term now when I go abroad here, but the trade, and I see some of you writing it down, I'll take a 1 cent royalty, that's all I ask. But when we look at the trade-demic, that means you have to figure out different ways around that scenario. Small example, last night our pilot says, we have weather on our way from Miami to Chicago. We're not going to take our regular route over land. We're going to have to go over the ocean and come around. It took us a few more minutes. It was smooth. You have to think like that. And I will add, what is old is new and what is new is old. The concepts, when we talk about IEEPA, it's a tariff. So how do you manage the tariff, right? We're going to, the concerns there, SHEILA, are what we've always been having to deal with. How do we look at who has the right to make entry? How do we look at, I don't think we mentioned yet, delivered duty paid, landed transactions, where all of a sudden the whole idea of reimagining the supply chain is, well, I was always the retailer, the ultimate purchaser consignee in that transaction. I think I want to be the importer now. I think I want to restructure it. Or, hey, let's just move it back so that we don't even have a US importer. Let's use that foreign price. Well, we might be missing a few steps there with the non-resident importer we were talking about. We might have some problems if all of a sudden it's a delivered duty paid transaction. Maybe you're on the other end of that you're going to be delivered duty paid. You don't have that visibility. We have now had to come up with a suite of services. We always had them, but we had to dust them off, which is gaining visibility when you're the ultimate consignee. Are you even being listed as the ultimate consignee on the entry form, on the 7501? If it is a non-resident importer, you're going to need a US consignee. That's very important to understand how that matches up. Foreign importer of record, you're going to need a US consignee, whether it's that first purchaser, or it could be a warehouse. So as a result, this is creating a lot of, I think, confusion. I could tell you right now, it's going to be cleanup on aisle 9 and aisle 10, 11, 12, 13, 14, throughout the whole supermarket, the way we're looking at it. And these valuation schemes that were alluded to before, rampant. Just the craziest questions are being asked because, look, so SHEILA, we're talking about a global tariff. That tells me, regardless of where you classify your goods, you're going to be faced with the tariff. The tariff's all encompassing. So classification engineering, going to be kind of difficult unless you're in a unique steel and aluminum situation, and maybe you want to work and see what amount is not steel, what is, do I need to classify it as an auto part or not? So I think you have some of that, but I think to an extent we were looking at production or origin engineering for a while, but it doesn't matter because pretty much wherever you go, China was a problem, but we all thought Brazil was good until last week. Now look at Brazil. So we are getting a lot of calls, especially me in Miami. What do I do? What do I do if we're a Brazilian company? And I will tell you, if you look at all of, just as I go on a little tangent, Brazil, and you look at their exports globally out of Brazil, the US counts for about 11.4%. They may say, we'll deal without the United States. So those companies might be stuck. But we have to see, they got a 40% plus a 10%. So now people are saying, I don't want to be Brazil country of origin, but last week I did. But it's really going to come down to, I think, the value of your goods. And that's where a lot of people are trying to navigate the IEEPA lawfully and in an illegal way as well. There's been a lot of talk about first sale. That's going like hotcakes. This has been going on. We litigated the first case, which customs came to our client and said, that's fraud. You can't use a first sale value. You can't use the price from a Chinese manufacturer to the Hong Kong tailor. You have to use the price that Hong Kong tailor charges to the US importer. That's fraud. It turned around, they said, that's a good business practice. Use that first sale of export. I hear reports and I shudder when I see it when they say, that's the loophole. That's the IEEPA tariff loophole. You know what I say? That's national security. Why is that national security? Those companies are the most compliant companies in the country, if not the globe, and they are taking the extra steps and due diligence to reach out further in their supply chain, identify those manufacturers, get the purchase orders, invoices, proof of payment. Sounds like a forced labor review a little bit, doesn't it? They're in the best spot to do that. And and I discuss that with the administration any day of the week. That is national security, and those companies should be awarded for that. They should be rewarded with that lower price because it's feasible. Our trading partners don't do that, but I think it's a model that works, and I think it's very viable and needs to be considered. So there are some really good opportunities there that companies are leveraging, and there are folks who are just simply saying, we have related parties, so let's just lower the value within the relationship or create a non-resident importer entity, and that's going to be major cleanup very soon.
You mentioned DDP, the China tariffs, the global tariffs that we're facing. Clearly, there are other supply chain challenges that our clients are seeing. Can you talk on those for us, please?
Yeah, so there's just this whole new world, not only from those challenges, but I think there's also the challenges as well, as we mentioned, in the e-commerce space, that people having to realign. As was previously stated, e-commerce is here to stay, but the clearance is going to be done differently with the 0111. There are a lot of folks just simply doing it wrong. And here's the problem with it, that our laws and regulations are nowhere near where we stand today as a business community. Let's take right to make entry, right?
Mm-hmm.
There's not a ruling out there that says that an e-commerce platform has the right to make entry. Some of them are, in fact, serving as an importer of record, and I absolutely feel they have the right to do that. But when those right to make entry directives, I think it was said in 2003, I agree, was probably the last one, an e-commerce platform, what's that? It didn't even contemplate it. So how are we then able to look at those guidelines and we're able to understand how to follow through with that if, we simply don't have that? I think there are issues, very big issues, other challenges. If you're using the sectoral tariffs, if you're looking at auto, if you're looking at steel and aluminum, and it's very complex, again, the valuation as to how you're going to determine the valuation of your component, if you will, the content value for the steel of aluminum versus when it's the non-steel and aluminum. And if you look carefully at the copper 50%, there is language in there that clearly said, if you don't have anything but metal in your product, maybe it's going to be annealed, maybe it's going to be coated, painted, there's additional labor by the third party. There's language in there saying, well, maybe you need to include those in your steel and aluminum value content or your copper content. I would argue no, I don't think it supports it, but it's just not clear either. And then, SHEILA, I think the big one we're looking at as far as challenges in the supply chain, maybe we're getting ahead a little bit, is this whole concept of transshipment. And just how people normally, regularly, it didn't matter a few weeks ago if you were taking Chinese materials or components, shipping them to Vietnam, and lawfully claiming the product Vietnam if you had a substantial transformation, or lawfully saying this is, Chinese, although it was going through Vietnam. But unfortunately, we still don't have that clarity as to what is this newfangled transshipment concept. I don't even think it's a transshipment concept, this 40% that's going to be charged on it. They could go back and say, oh, you entered your goods, but you owe this 40% for transshipment, or we'll get you on liquidation, because it almost seems to be just focusing on the content, similar to how you would assess an AD/CVD duty, that if you have the aluminum and the aluminum extrusion, wherever it's coming from, you're under the scope and you're going to have to pay that duty. I see it almost more as a scope-based type analysis. But again, in the CSMS, it simply said, if there's evasion, we're going to charge the 40%. Well, evasion is a penalty concept, and the penalties still exist, but all of this is going to stack up potentially. So just how people are doing sourcing, they still don't have the message today post the IEEPA modification as to what is this new concept of transshipment. When I go in, I have the privilege with some associations and clients to meet directly with administration officials. And I will ask USTR, what is this transshipment concept about? Some of these folks are the ones actually issuing and writing the executive orders. And they'll say, we just don't know yet, but we know it's something different and we're not sure yet, and CBP isn't sure yet. So these are the challenges that it's just not clear whether it's, you know, a sectoral tariff, whether it's a transshipment tariff, whether it's going to be this type of origin issue we're looking at. These are all the pieces that go into the mix.
Absolutely. We were talking about challenges, Karen, and you'd mentioned E&O earlier, and I know one of our biggest recommendations is for everyone to be looking at their limits. Maybe you can touch base about why your limits of E&O are so now more so important than they used to be.
Yeah, thanks, Sheila. So I would say over the years, for many years, the number one cause of loss for an E&O claim was misclassification of goods. So that's still prevalent today, but even more so than it was before, because it's such a fluid situation that the rates are constantly changing. That's going to continue to be one of the number one causes of loss. The second one, I would say, are failure to file protests timely. So these are really two very big main causes of loss that you want to make sure you have the proper E&O limits to cover the exposure. You know, 20, 25 years ago, we had many clients, and even still today, who choose as a limit $100,000 as an example. That's just too low in today's environment. $100,000 in legal fees to defend you against an allegation of misclassification is just not enough money. That's going to get exhausted pretty quickly. The demands are going to increase, of course, because the value of goods have increased simply. And so you can expect the exposure to increase. I feel like the limits haven't really caught up with today's economy, really, even in a way. So where you saw $100,000 before, it's too low. Even I would even argue probably 250 is too low in a limit. You know, maybe the gold standard is a $500,000, depending on, of course, your business model and your overall exposures. And then, of course, you know, there's ways to protect yourselves for an E&O against an E&O claim. Proper terms and conditions of service. Lenny talked a bit about it today and what you can do to modify maybe those terms and conditions. The NCBFA has great established terms and conditions that have been tested in court over many, many years. And so that's a good place to start as far as proper terms and conditions. But there are ways in which you should use your terms and conditions as a way to enforce them and any allegation that's being made against you. So things like incorporating them in your power of attorney, in every signature line on all of your emails, in your invoices that you issue to customers, on your websites. These things have to be very visible. You have to give really a client every possibility to say they saw and have reviewed and read your terms and conditions. If it's even possible, and if it's an online platform, provide a link to those terms and conditions and allow them maybe not to get to the next step until they've accepted your terms and conditions. There's little things that companies can do to protect themselves in the event there's an allegation of wrongdoing being, you know, made against you.
Yeah, I'm really glad you raised that, because I think when we look back, the NCBFA just updated terms and conditions power of attorney just a few years ago, and I think they're good. I really feel we did another kind of scrub at it, say, hey, in this new environment we're in, are you protected? And the limitation of liability, the indemnification clauses, I think you're going to be covered. But I agree, Karen, the problem that I see is a lot of intermediaries, brokers, they will not have that visibility to it. And the clients say, I never saw it, you never told me about it. And that could be like a chink in the armor, so to speak, that you need to deal with.
Yeah. If you're a customer that hasn't, they could say they never saw them, it's hard to defend against it. And you might be like waving the red flag. Well, I did. They're on my website. Well, they're on your website embedded, you know, 5 pages into an other section of your, that's, you know, it's hard for any court to say, yeah, you're right, they're there. You should have seen them and knew that they existed. So,
in talking about E&O claims and protecting yourselves, what do you think or see are ways that our clients can protect themselves from customs and other regulatory agent claims being filed against them directly?
Yeah, so Lenny and his firm, we partnered with Sandler Travis to provide a regulatory defense contract. So if you don't have regulatory defense today, it's prepaid legal advice that will protect, it'll help draft protests that you need to file, protection against liquidated damage claims and others. You've seen a lot over the years.
We have.
I mean, how have you seen it change, or have you seen an impact as a result of the tariffs
You know,
today?
what's interesting is we haven't seen that much of the impact yet.
Yeah.
From the questions we're getting and the changes that we are hearing about and seeing, we think it's around the corner. That's the interesting part, that it's been eerily quiet in certain ways. However, what we have seen is we see customs, as has been stated, they're getting more aggressive. They're very enforcement oriented. We have seen situations where typically there would have been a request for information notice of action going to the importer, and one or two of the centers go straight to a letter of investigation. It has been very clear language in the executive orders, especially steel, aluminum, the sectoral tariff, saying we will go straight to penalties, and we are instructing customs not to grant any mitigation. If there is, now they say no mitigation. They didn't say there can't be a settlement or an offer in compromise. I was reading the fine print there. So there may be a way to go. So we have to remember that. But when the administration is saying straight to penalties and no mitigation, I question whether that's lawful. But again, the executive orders, better for worse, are really the law of the land. So I'm concerned that there's going to be a lot coming around the corner. And was stated before, there is an eye on brokers, that when I speak to the leadership at customs, they, one or two individuals have said, you know, the customs brokers need to step it up. I'm like, well, what does that mean? I think CBP and the government needs to step it up, with all due respect. I said, we all need to step it up, don't we? And I said, well, okay, Lenny, that's a fair point. You know, I try to bring us all into it when I can, but that type of mentality shows that they're looking. And here's the rub. Not all brokers were created equal and are functioning equally. What we've seen is not only this rash of non-resident importers, but who are going to be those brokers willing to file on behalf of them, or accept the challenge, which I do not like the challenge, which is you serve as importer of record. You here at Roanoke, and all of you probably in the brokerage industry, you're getting those requests. I know you are. Will you be my friend? Will you be my importer of record? My answer is you will not be the importer of record, because then CBP will come after you and with even more intensity. And it's happening. And the companies serving as broker importer of record, a lot of them are not doing it properly, from what I'm seeing. A lot of them are absorbing those e-commerce transactions where you probably don't even have a party with otherwise the right to make entry or even hire you necessarily to play that role, or have the right value or the right classification. So I'm very concerned about this trend that I'm seeing. And as a result, because CBP is seeing it, they're kind of, I think some of them saying maybe a few bad apples spoil the bunch and there needs to be enforcement. I will tell you this, I am hearing rumblings now that we're kind of a bit on the other side of the IEEPA tariff modification, you're going to see enforcement executive orders, and it is going to be like nothing we've seen before, and it's going to be brokers and importers, and you might see new parties playing potentially different roles, and we still might see an external revenue service, which is really going to topple everything on its head from what we know. So
That's fantastic. And let me just thank you both for your expertise and your time today. We're going to take some questions. Thank you right now.
On that dire note, we're going to move to questions. Lenny, could I get you to sign a waiver for us to rebrand this as Surviving the Trademic?
Surviving the Trade
That would
Demic,
be
you
great.
got it. We should have called it that, right?
Right, we should have.
Okay, so we have one here from online. You touched on DDP. Are buyers at any risk when purchasing DDP if the shipper has set up a shell company in the US in order to assume the role of importer of record?
So when I hear shell company, I say, I don't think that's a lawful importer of record, right? So if you have, so partially what's going to happen is CBP is going to say, let's see what that shell company is all about. I would hope that maybe, you know, Roanoke might have looked at that company and said, maybe we don't give them a bond, but maybe in this case they slipped through and they did. It could happen. That is not necessarily Roanoke's role to be the police for customs. You look at the financials, you see what's there. If you're involved as the customer's DDP, they very well could look at you and say, hey, maybe we need to look at enforcement against you. And this is very, very important point to directly answer your question. The 1592 penalty statute for negligence, gross negligence and fraud says CBP can issue a penalty claim against any person who is involved with the false statement, omission at the time of entry or an attempt to make entry. Last time I checked, DDP entities are persons. So,
Wow.
yeah,
Interesting.
you have to be
That is-
careful.
That's intense. Do we want to open up to anyone here in the room? Does anyone in the room have a question?
Oh,
Okay,
Rob does.
gonna hand this over. We're gonna do the mics. Okay.
If tariffs are turned on their head under the current schemes, what's next in your view, Lenny, as to where we're headed, what Trump's going to pivot to, and are they here to stay? Will the Democrats hold on to them as well? Because they didn't reverse Trump's prior tariff regime. So your views on that?
Right. I'm so glad you asked that because that was something we wanted to get to, but we kind of veered around to other areas. So look, there's lots of ways to tariff imports. The Section 232s, the Section 301s, which are still challenged at the Court of Appeals Federal Circuit. There's the IEEPA tariff. Then there's a whole bunch of other tools in the toolkit. So hypothetically, if it all goes south at the Court of Appeals Federal Circuit, by the way, who quote unquote, as I liked it was reported, gave a frosty reception to the government, because there's one little problem with IEEPA. The word tariff doesn't appear in the statute. There is a question as to whether the Court of International Trade had jurisdiction over the claims to begin with, because it's not tariff. What is IEEPA? For those of you who are like, what's this IEEPA stuff about anyway? Think of Cuba, think of North Korea. That's really what it is for those sanctions, those embargoes, now for tariffs. Possibly it goes away. Very happy day. Everyone has their real tariff liberation day, and all the duties are returned. Might have to file protest. Good chance you won't have to. It'll go through the refund cycle. The next day, they're going to use one of the other statutes and say, we'll do a deficit tariff, or we're going to do the 301 tariff. So I think there still will be tariffs. It's a question of, and just in our wildest imaginations, maybe not. Maybe this is found to be invalid, and then we have to start over again. I will tell you this, there's already been reports that the USTR, Jamison Greer said, we have our plan B in place just in case we don't do well with this. And by the way, just a little note on that, if you look at the de minimis executive order, they made it very clear, we are suspending de minimis. And by the way, this is independent from whatever happens with the IEEPA tariffs. They made that very clear just to cover themselves. I think they have grounds for that. I think what they do with de minimis, and they've said we're going to instruct CBP to issue the regulations, which they kind of started to do already. De minimis, I think the ship has really sailed there, regardless of IEEPA, but let's see what happens. But there will be tariffs one way or another, in my opinion. Yep.
Pesky tariffs.
Pesky.
Okay, we have one more here online. AI was a big topic of y'all's session. We have a question here that says, more and more companies are adapting to the use of AI. Any thoughts on liability exposures? Are liability E&O policies being adapted to respond? And lastly, any concerns for those that are currently using the NCB, FAA, T&C? Do we need to think about changes?
So as far as the TNCs go, I think we're in good shape there. I have advised some brokers. I said I'd feel more comfortable, management would feel more comfortable if we put language in fact, about the tariffs, and if in fact that they are changing rapidly, and the importer is responsible to exercise reasonable care in that regard. And I don't think that hurts to kind of have your tariff clause in there as well, because everything is just so fluid right now. As far as E&O goes and using AI, again, it's really, to me, not that much different from if you go onto Google, if you do your research in an automated fashion, you really have to do that due diligence. But again, I would really encourage all of you to look at having clauses, first and foremost, that alert your importer clients, make them aware that you might be using information from EI, or more importantly, providing some of their information to an AI provider, if that's the case. So at least from the ground zero, you have that notification, and you are of like mind when it comes to confidentiality. But again, I think from an E&O standpoint, it's going to really be the same concepts of due diligence and just using it as a tool and not a substitute.
Yeah, let's go ahead here. Let me hand you this.
So will the NCBFA be making suggestions to an updated power of attorney for that?
We're not.
language?
So we
No.
do feel at this point that the powers of attorney and terms and conditions cover you. It's
Okay.
been, I would describe it more as a belt and suspenders that some companies have decided to, take another step. But we probably should still have that discussion. I think it's not a bad idea as we think through it to say, hey, now that AI is becoming so prevalent, maybe we do need to put a piece out on that.
Mhm.
So at this point, we're not. We think you are covered, but I'm always happy to explore that if the industry feels that that might be useful.
Okay. If we are using AI tools and we are not putting in importers' names or anything proprietary as far as a product and using it as a starting point to get to a right regulation, do you think that's a best practice?
I
Or is
need
it
to,
still
I need
an
to get
issue?
more, that's
Yeah.
like the tip of the iceberg. I'd want to know a little bit as to, look, the fact of the matter is you all have been using automated tools
Google.
for
right.
decades.
Yeah.
Or you've been, you use EDI, you use different, you've been using all these sources for years. So the question is, how has your business operations changed as a result of the AI capabilities you have now? And my concern is that maybe it is becoming a substitute for someone who's doing the classification, looking to see, oh, we have bananas coming in from Norway. That's probably something that you need to do some due diligence on.
Yeah.
And
I
it's
mean,
sort of proper vetting too,
And vetting.
the background checks, constantly and continuously reviewing is, one-time review is not good enough. Constant, continuous reviewing is
Right.
important.
Reviewing, and we didn't mention the word audit today yet, but you really
Yeah.
need to be auditing. You really need, some brokers don't have the time to do it. I can tell you, if a broker was to jump right in now and do an audit over what they've been filing the last month, they'd have to find something that needs to be corrected. And I'm saying that with all due respect, because it's been just so fluid.
Yeah.
Excellent. We have one more here that came through from online that says, what are some common pitfalls or mistakes that are made when trying to mitigate risk and avoid E&O and regulatory claims, and how can those be avoided?
When trying to avoid them
Mitigate.
or mitigate them.
Yes,
Mistakes.
mitigate. What are some common pitfalls or mistakes that are made when trying to mitigate risk and avoid E&O and regulatory claims, and how can those be avoided?
First thing you should do is not admit liability.
That's
So
true.
let's say that.
That's true.
So if you're unsure, consult with the insurance
We've
company,
seen
your
that before.
lawyer.
Yeah.
Yeah, I would say that it's probably first and foremost. We see that a lot where you want to just immediately be like, yep, it was me. I made a mistake. Don't do that. 'Cause that might void any defenses that you have available to you and void coverage under your policy. So I would say be very careful.
And I think
And
the other
that's
thing is to self-blind and actually not get that to us in a timely manner so we could look at it and help out and come up with strategies, because sometimes certain options, your right to appeal, your right to challenge might already have been exhausted, and then we're kind of left with only one foot to stand on instead of two. So I think you want to own up. I think you want to face it forward, but keep it between your counsel, your surety, et cetera. And we have had those cases where, oh yeah, I admitted to,
Yeah.
my customer I was wrong. Don't do that until we tell you you have to, if you do.
Never wrong.